Flanagan, partner and co-chair of Foley and Lardner's food and beverage industry team. I'd like to welcome you to our newsfeed webinar, Food and Beverage Class Action, Advertising and Labeling Lawsuits. My colleagues on the panel today include Craig Folkler, Aaron Weinzierl, and Jacqueline Wallace. Craig Folkler is a partner and intellectual property lawyer at Foley, where he's the chair of our Chicago Intellectual Property Department and a member of our food and beverage industry team. Craig is experienced in all aspects of domestic and international trademark, copyright, and unfair competition law, and has represented a wide variety of clients in the food and beverage industry. His experience includes litigating trademark and advertising issues throughout the United States and a number of foreign countries. Aaron Weinzierl is a senior counsel and an intellectual property lawyer at Foley, where he focuses his practice on resolving intellectual property disputes in trademark, advertising, trade dress, patent, and copyright matters, and in counseling clients on intellectual property issues. He's a member of our food and beverage industry team and has assisted food and beverage industry clients in consumer class actions, challenging labeling and advertising. Jackie Wallace is an associate and intellectual property lawyer in Foley's Chicago office and also is a member of our food and beverage industry team. Jackie has a wide range of experience in intellectual property prosecution, counseling, and litigation, including trademark, copyright, trade dress, false advertising, and unfair competition matters, as well as other complex civil litigation. She counsels numerous clients in the food and beverage field and has experience in consumer, food, and beverage labeling and advertising class action litigation. Before we start, I'd like to go over a few housekeeping tips. Today's program will run for 60 minutes. We will apply for 1 general CLE credit for today's program. For those of you interested in CLE, please listen carefully for the code that we will announce at some point during this program. Once you hear the code, a polling question will pop up on your screen. Please be sure to enter the code into the polling question. For those in New York, New Jersey, and Kansas, you will also need to fill out an attorney affirmation form, which can be found in the resource list widget. Electronic questions can be submitted throughout the broadcast by clicking on the Q&A tab at the bottom of your screen. Now, it's my pleasure to turn the program over to our first speaker, Craig Folkler.
Thanks, Mike. Well, it seems it wasn't that long ago that when we heard the phrase consumer class actions, we were thinking more about tobacco, asbestos, medical product injuries. There are also environmental claims and SEC violations. That's all changed. Today, class actions are brought against virtually every type of business under a wide variety of legal theories. There's employment issues for discrimination, RISA, overtime pay. Then you get into even antitrust violations are being alleged by consumers. There's a series of 23 antitrust violation class actions pending right now against the makers of the Keurig brewers. The consumers are complaining that the violation of the antitrust law caused them to pay more than they should have for Keurig products. Breach of product warranties claims are becoming more popular, and there's deceptive advertising, products, services, financial terms. Reason for our webinar today is that currently the most targeted activities are those of the food and beverage companies, particularly the labeling and advertising. In the last 5 years, over 1/3 of all the cases that have been filed, the consumer class actions, have been against food and beverage labeling and advertising. And there's no sign of it tapering off. We take a look at the next few slides. I'll give you a moment. You get a small, sort of an idea about how pervasive this is. And these are only a partial list, what I'm going to show you, of the companies and the products that have been attacked with class actions during recent years. You can see it's virtually every type of food and beverage product imaginable. And the list keeps growing all the time. And you also note it's not just always the major companies. There's a lot of smaller ones as well. So it raises the question, why are food and beverage claims so popular? Well, there's actually a lot of reasons. One of them is that there's a huge pool of plaintiffs, everyone. Everybody consumes food and beverages. There's also a huge number of potential targets and target products, companies. One trip through the grocery store starts to give you a small idea of the innumerable food and beverage products that we have and available today, and more are being offered all the time. Another reason is that a lot of times competitors in these industries will copy each other's claims. They'll compete on the same basis, making the same claims about their products. This makes it an attractive target for a class action plaintiff's lawyer. If he comes up with a case against a claim that's being made, he can go through the industry, competitor by competitor, knocking off one, getting the money from one case to help fund further cases. Another reason is that deception, which is usually alleged in these cases, is a state of mind violation. It's not. There's no skid marks to measure to get rid of it easily or cleanly. It depends upon what the consumer understood the claims on the package to mean, and that doesn't just mean the express claims. The class action complaints today most frequently allege implied claims. They look at various elements on the package and say when you put them together, they mean something different than their literal meaning. Another part of the claim is the consumer has to say they were misled and that all others like them would be misled. Well, just to make the pleading, it's really pretty easy for the consumer to say that. They mentioned that they relied upon it when they purchased the claim that they say they understood. And also, if you get the proof issues down the road in the case, you're starting to talk about just the reasonable consumer as a threshold question, something that can't be knocked out on a motion to dismiss or actually easily on summary judgment to start. Also, another reason we're getting all these cases is that plaintiffs' lawyers have numerous sources from which to obtain ideas for claims. You got your regulatory agencies, the FDA, the FTC, the USDA. They issue letters, they file complaints, they announce settlements and consent decrees. Frequently, class actions are filed within days of one of these announcements. Self-regulating organizations, the NAD of the Better Business Bureau, not quite as apparent what they're doing, as easy to find, but nevertheless available for those who are really looking for possible claims. Activist groups. Some people think that they exist not to protect the consumer, but just to criticize businesses. In any event, their publicity of wrongdoing, supposed wrongdoing, or alleged wrongdoing by companies has led to very, very many class actions. The Internet itself, you have bloggers with their opinions, you got consumer complaints on some sites, just review sites. These are all fodder for the class action plaintiff's lawyer. Competitors' actions. We see cases where two competitors are engaged in litigation. The plaintiff claims that the defendant is engaged in false advertising, and suddenly we've got copycat consumer class action cases springing up. I mentioned the Keurig case earlier. Well, there's false advertising claims. That case was started by two competitors with antitrust and false advertising, and now there's about 23, I think, class actions claiming false advertising as well as the violations of the antitrust law. Broad consumer protection laws, friendly courts in certain jurisdictions, California, I think that most people are aware of, Illinois, Florida, the New York federal courts. These courts, particular courts I just mentioned, seem like they're just going to clear out every obstacle that the defendant companies put up. We go through one series after another of seemingly changing the requirements for class actions to make them easier. Then there's the plaintiff's lawyers. Plaintiff's lawyers know the companies are usually going to settle. Matter of fact, we've looked, but we're not aware of any false advertising case going to trial. And the plaintiff's lawyers make it more convenient or more desirable because they're willing to take less than it would probably cost to litigate the case. These cases are about what the lawyers get. They obtain exorbitant fees. Some courts have recognized that they're primarily for the lawyers' benefits. There is a judicial trend, luckily, to reduce the fees being awarded. For instance, the Ninth Circuit has taken the position that the fees shouldn't be more than 25% of the recoverable damages. Now that we know why it's happening, we're going to go to Jackie and to Aaron, starting with Jackie, to discuss what exactly it is that's being alleged in these cases. Jackie?
Hi, all. I'm going to give just an overview of some of the general types of claims that have been pled, followed by a review of some of the recent complaints that we're seeing and decisions of note. So first, plaintiffs have alleged statements regarding the composition or content of a product, including statements that a product is all natural, organic, or contains evaporated cane juice, are misleading, and or that the products are misbranded. In addition, plaintiffs have alleged that a failure to warn about or disclose the contents in a product is unlawful or unfair. Plaintiffs have also alleged statements regarding the condition of a product, such as fresh, raw, or unpasteurized, are misleading and that the products are misbranded. Plaintiffs have pursued claims against products containing statements or descriptions related to health facts, such as healthy, antioxidant, immunity, or metabolism, alleging that such statements are a form of misbranding or that the statements are misleading or deceptive. Plaintiffs have also pursued claims against allegedly misleading statements regarding the origin of products, including made in the USA, the description of manufacture of a product, and false testimonials or certification statements. Now I'm going to go over some recent complaints that have been filed against food and beverage products. Hopefully the discussion will give you some context for the breadth of claims that are currently being pursued, as well as some of the more recent issues or developments that should be monitored. As I mentioned, plaintiffs are pursuing claims about unlawful, unfair, or misleading product composition descriptions or omissions. We are continuing to see claims against all natural or 100% natural descriptions, including when the products contain an alleged artificial or synthetic ingredient or ingredients that are even subject to extensive processing. As you likely are aware, the FDA does not have a formal definition of the term natural, but the agency considers use of the term on a food label to be truthful and non-misleading when nothing artificial or synthetic has been included in or has been added to a food that would not normally be expected to be in the food. As I will discuss in more detail shortly, the House recently passed legislation under which the FDA would be directed to come up with rules formally defining how natural labels can and should be used, which is something to monitor and keep on top of. The USDA has advised separately that natural may be used on labeling of meat and poultry so long as the product does not contain any artificial flavor or flavorings, color ingredients, chemical preservatives, or any other artificial or synthetic ingredient, and that the product and its ingredients are not more than minimally processed. So in a recent complaint filed against Inco's Tea, the named plaintiff alleged that Inco's tea beverage products were deceptively labeled as 100% natural when the products contained ascorbic acid. The plaintiff alleged that ascorbic acid was a highly processed ingredient regularly used as a preservative, and that all natural means the product contains no non-natural or synthetic ingredients and consists entirely of ingredients that are only minimally processed. In support of the plaintiff's claims, the plaintiff actually cited to the USDA's listing of substances that can be included in organic products, which specifically identifies ascorbic acid as a synthetic. the case actually settled not very long after the complaints were filed, actually in July. I want to point out here a recent decision from a California district court, which granted summary judgment to Dole in a case asserting that Dole's frozen and packaged fruit products misrepresented that they were all natural when they contained ascorbic acid and citric acid. The court actually relied on the FDA policy on natural and found that plaintiff had failed to present evidence that a reasonable consumer would not expect citric acid and ascorbic acid to be in the accused products. And so the court found that the named plaintiff's testimony alone was insufficient to defeat summary judgment. But that decision is on appeal to the Ninth Circuit, so we'll see what happens with that one. Several recent copycat complaints have been filed alleging use of all natural on product labels is misleading when the product contains sodium acid pyrophosphate. The claims are based on a recent warning letter sent by the FDA to a bakery asserting that its pancake product was misbranded because the package bears the statement all natural but contains SAPP, which the FDA stated was a synthetic substance which would not normally be expected to be in the food. So that's that picture of the scones there in the middle. They have an all-natural statement on the side but contain sodium acid pyrophosphate. In that case, an answer was actually filed, so we'll see what happens. In addition, we're seeing claims against the use of all-natural when the product contains GMOs. So that's the Gold Moms package there in the slide. A recent complaint was filed in Florida alleging that natural and tasty Gold Moms quinoa crisps were deceptively represented as all-natural and GMO-free, despite the fact that the products contain unnatural, synthetic, artificial, and/or genetically modified ingredients, including maltodextrin, whole grain corn flour, barbecue seasonings that contained additional ingredients, and vegetable oil. The plaintiffs asserted, upon information and belief, that almost all corn and soy grown in the United States are grown from seeds that have been genetically modified, and as such, almost all corn and corn-based, as well as soy and soy-based ingredients in the U.S. are in fact unnatural, synthetic, artificial, and genetically modified ingredients. The case was actually settled and dismissed in May of this year. An additional point to note regarding GMOs is that on July 22nd, the House passed H.R. 1599, the Safe and Accurate Food Labeling Act. The main purpose of the act was to prevent state and local governments from regulating the use of genetically modified plants in food if the regulations would affect interstate commerce, which would include, obviously, labeling regulations. The main purpose was to prevent the different states from putting out their legislation on GMO labeling. In April, there were at least 62 active GMO labeling bills and legislation in 23 states. Mandatory labeling laws have passed in Vermont, Connecticut, and Maine. The Vermont law is actually set to go into effect in mid-2016. And as I mentioned, one of the important parts of the current proposed legislation is that it would direct the FDA to come up with rules formally defining how natural labels can and should be used. Now we'll turn to partially hydrogenated oils. On June 16th, the FDA issued a determination that partially hydrogenated oils, the primary source of artificial trans fat in processed foods, are no longer recognized as safe, or no longer generally recognized as safe, so GRAS, for use in human food. This was based on scientific evidence finding that the intake of trans fat increased the risk of heart disease. In its determination, the FDA set a compliance period of 3 years to remove PHOs from food products, or to petition the FDA to permit specific uses of PHOs. So there have been several recent complaints filed alleging that the use of PHOs is unfair and unlawful because the FDA declared it unsafe for use in foods. Such complaints have also alleged that use of 0 grams trans fat statements are claims about the healthy nature of a product, which are misleading because the products contain dangerous PHOs. In response, defendants have filed motions to dismiss, arguing, amongst other things, preemption, safe harbor, and primary jurisdiction doctrine. So those will be important cases to monitor as this moves through and as the FDA, works through what the compliance period and any specific petitions received and just the court's interpretation of those different doctrines. In a recent decision from the Northern District of California regarding Nissin's cup noodles products, the court found claims regarding 0 grams trans fat statements were expressly preempted because they would compel a discrepancy between the front label and nutrient panel, which would be confusing to consumers, and would impose a burden not identical to the FDA requirements. But the court declined to dismiss other claims that were based on the use of PHOs in products on preemption grounds. The court found that despite the recent determination, the FDA had previously declined to issue a regulation permitting or prohibiting all artificial trans fats. Thus, there was no safe harbor protecting the ingredients from California law. The decision does not appear to address primary jurisdiction or conflict preemption, so it remains to be seen how that decision will impact some of the other claims that are proceeding in the courts. Now we'll turn to organic, claims against organic statements. As you may be aware, the USDA oversees the National Organic Program, which has issued regulations defining organic and providing standards for organic labeling claims. Specifically, organic products must be produced without excluded methods, which would include genetic engineering. They must be produced in accordance with the list of allowed and prohibited substances and must be overseen by an authorized certifying agent following all USDA organic regulations. The percentage of organic ingredients in a product will impact the type of claim that's permitted. The USDA regulations actually permit more restrictive state organic programs for the production and handling operations that occur within the state, and one such example is COPA, or California's organic program. The FDA does not have a definition of organic and actually refers back to the USDA's regulations. In a recent complaint filed in the Eastern District of New York, a plaintiff alleged that Similac organic formulas were deceptively labeled because the product contains ingredients that are not permitted in organic products. In June, Abbott requested permission to file a motion to dismiss, arguing, among other things, that the products were certified and claims seeking to overturn certification are preempted. Federal law allows the ingredients and that the USDA is primary jurisdiction over organic labeling for infant formula and is actively engaged in rulemaking. A recent decision from the Southern District of New York, however, denied a motion to dismiss that argued claims against organic statements on food and body care products were preempted or barred by the primary jurisdiction doctrine. So even though the fact that they were certified did not preclude class action complaint going forward. Now we'll turn to evaporated cane juice. In 2009, the FDA issued draft guidance advising of the FDA's current view that the use of evaporated cane juice is misleading because it's not the common or usual name of certain sweeteners. Many cases have been filed alleging that evaporated cane juice on labeling was misleading, and those cases were stayed under the primary jurisdiction doctrine pending the FDA's final determination or final guidance. In one case, a consumer brought a class action against Late July snack foods, alleging that products bearing the phrase evaporated cane juice are misbranded under the FDA and California regulations and are misleading because ECJ is not the common or usual name for the sweetener, and consumers would not know that ECJ is added sugar, or evaporated cane juice is added sugar. In February 2014, the defendant filed a motion to dismiss, arguing primary jurisdiction, and the case was subsequently stayed. Last month, the FDA actually responded to the court's request for further information about when the FDA would issue final guidance and advised that final guidance is anticipated to issue before the end of 2016. Now we can go on to Proposition 65. Proposition 65 is a California statute that prohibits businesses from knowingly exposing individuals to over 900 identified substances, which have been determined by the state of California to cause cancer, birth defects, or other reproductive harm without providing a clear and reasonable warning. There's been proposed rulemaking which would require in part more specificity in the warnings, including the identification of certain chemicals, and also modification of the labeling of the language to warnings, which would be modified to consuming this product can expose you to a chemical known to the state of California to cause either cancer, birth defects, or other reproductive harm. There's also a proposed bill that would eliminate the knowing and intentional exposure if an exposure assessment is obtained prior to receipt of a pre-suit notice, so hoping to avoid some of the additional litigation if companies actually obtained an exposure assessment prior to receipt of pre-suit notice. Recent complaints have been filed alleging violations of both Proposition 65 itself as well as violations of other false advertising and unfair competition statutes based on unfair and unlawful omission theories. Specifically, in several recent cases in California state court, plaintiffs have brought suit under Prop 65 for failure to warn that there was cadmium in cocoa powder and lead in caramel coating. For just briefly, for Prop 65 claims, notice is required prior to bringing suit, and plaintiffs can seek a civil penalty of $2,500 per day for each violation, 25% of which is recoverable by the plaintiff. They can also seek an injunction, reasonable attorney's fees, and costs. In a recent case in the Southern District of California, plaintiff alleged that the defendant failed to disclose material facts about the presence of 4-MEI, an alleged carcinogen created during the browning process for caramel coloring, which was contained in its Goya Malta and other beverages. Plaintiff alleged violations of California unfair competition and false advertising law in addition to Prop 65. In March, the court denied a motion to dismiss the claims on preemption and primary jurisdiction grounds. So now we've got claims against just condition description, which a recent case was filed against use of fresh. Plaintiffs alleged, among various other things, that Whole Foods in-store signage stating freshly boiled and baked plain bagel and product packaging statements, "We bake daily using only the freshest ingredients," were deceptive because the bread and bakery products were made and frozen or subject to other processing. In support of the plaintiff's claims, the complaint actually referred to FDA regulations that define fresh, that it would mean that it hasn't been subject to processing. So additionally, plaintiffs, we've seen recent complaints going after terms related to product health facts. For instance, healthy. In March, the FDA sent a warning letter to Kind, stating that certain of its Kind bar products were misbranded because they contain implied nutrient content claims suggesting the product is healthy in connection with claims about nutrients, but the products were not low in saturated fat as required. The FDA also alleged misbranding as a result of plus and antioxidant claims, amongst a variety of other issues. And there have been multiple piggyback complaints filed across the country making the same allegations as those contained in the FDA's letter. Antioxidant claims. In a recent case filed in California, a plaintiff alleged defendant's kombucha tea products were misbranded because the antioxidant claims in the packaging were not authorized under the FDA and are misleading nutrient content claims. The claims are actually on the package were with a unique blend of proprietary probiotics and powerful antioxidants. Each bottle is designed to nourish your body from inside and out. With more antioxidants than blueberries and more fiber than oatmeal, see for yourself how chia brings new life to our GT's kombucha. The plaintiff actually referenced FDA letters regarding RDIs and that the antioxidant claims weren't permissible under FDA regulations. A motion to dismiss in part was filed, arguing that the first claim about powerful antioxidants is preempted because powerful does not characterize the level of the antioxidant and is puffery. That's still in the briefing stages, so there's not going to be any decision anytime soon. I will now turn over to Aaron for a discussion of recent geographic origin and product manufacturer claims.
Thanks, Jackie. Another type of claim that we have seen recently are claims relating to the geographic origin of products and claims that the product source is misdescribed. For example, in one of these, the image of the product is over to the right. The plaintiff challenged the labeling and advertising for Himalaya goji berries. The plaintiff claimed that the defendant's product packaging is misleading because it creates the impression in the minds of consumers that Himalaya brand goji berries are harvested and transported from the Himalayas mountain range, when in fact they are harvested far away from the Himalayas. The plaintiff based this claim on a number of things, first being the suggestive mountain range in the trademark, the peaked A's, the portion of the front of the package, which is a window in to view the product that's shaped like a mountain range. There's also a statement on the front of the package, quote, "the most famous berry in the Himalayas," and similar statements both on the back of the package and on the website. Following the suit, the manufacturer there has removed the statement, the most famous berry in the Himalayas, from both the package and the website. Another one which you may have heard of is related to Anheuser-Busch's Beck's beer. Their plaintiffs alleged that Anheuser-Busch falsely marketed that Beck's beer is imported from Germany when in fact it's now actually brewed in the United States. Plaintiffs based this in part on the statement on the front of the package, quote, German quality, and also a statement that the beer is brewed under the German purity law of 1516. The plaintiffs also alleged that Anheuser-Busch sort of failed to disclose additional information about where the product was made. In response, Anheuser-Busch argued that German quality was mere puffery. The court looked at that and on a motion to dismiss declined to make a determination. That case has now since settled. You may have heard in the news, consumers without receipts may obtain up to $12 total based on 10 cents a can or a little bit more for a six-pack or larger packages. And then consumers with proof of purchase can obtain up to $50 for purchases from, I believe it was 2011 onward. There, the plaintiffs' lawyers were awarded $3.5 million in the aggregate to split among all plaintiffs' counsel. Another type of claim that we've seen relates to the method in which products are made or manufactured. Again, here we see some claims in the alcohol industry, but it's also happening in food as well. Fifth Generation Inc., which is the company that produces and sells Tito's vodka, was sued over the term handmade there on its vodka label. After an initial suit was filed, follow-on cases were filed in other jurisdictions by different plaintiffs. The plaintiffs similarly allege in most of the cases that the vodka is actually made by a highly manufactured or highly mechanized process using commercially manufactured neutral grain spirits in a large industrial facility and distilled in large industrial technology using sort of advanced technology and things that don't sound handmade. Similarly, claims relating to craft, and here craft beer, Miller Coors has faced a suit based on claims relating to Blue Moon beer and advertisements for Blue Moon. The plaintiffs alleged that it's actually a registered trademark, but artfully crafted, the registered trademark for Blue Moon beer falsely portrays Blue Moon as craft beer, and that Miller Coors omitted the Miller Coors name from Blue Moon products to suggest to consumers that Blue Moon is craft beer. Plaintiffs then relied on the Brewers Association definition for craft beer to conclude that Blue Moon is falsely advertised as a craft beer. It's not clear yet which of the advertisements the plaintiffs claim they saw before purchasing Blue Moon. That will be something to watch and how that case develops. Related to food, we've seen cases filed on packaging or labeling claims, advertising claims, such as made in store or made in house. Plaintiffs in New Jersey have challenged Whole Foods' advertising for baked goods that are labeled made in-house. They allege that the bagels and bread are pre-baked elsewhere, delivered to the store, and then either stored frozen or stored at a certain temperature and then reheated or half-baked prior to the sale. Currently pending before the judge in that case is a request for briefing from the parties, actually due today, on whether the claims can proceed on a class basis. So that'll be one to watch. And with that, I'll turn it back over to Craig to talk a bit about what can a company do to avoid false advertising class action claims.
Sorry. You have to keep abreast of the regulatory activity and class action claim trends that are going on. That's USDA, FDA, and others. If you want to encourage marketing, avoid using hot button terms, the things that you learn from keeping track of these things. This is all natural, undefined terms, pure, as we just saw, handmade. You go back to the basics. Thorough claim clearance. You have to have clear procedures and accountability for each step of the process. You need the right team, the right people involved looking at it to make sure that there just aren't some assumptions being made or wishful thinking about what the claims mean or whether they're supported. Again, compliance with the FDA, USDA regulations, and all applicable laws. One of the most important things about the claim interpretation, I think that what we've seen today with the creativity of the plaintiff's lawyers brings up, you have to look at all of the possible interpretations that could be made from a label or from an ad. It doesn't save you that each claim that's made on it is individually truthful. It's the combinations of claims, a few or all of them, or a combination of the claims and the pictures in the aggregate. Each of these possible interpretations, you have to make sure that there's adequate substantiation. If there's not, then it has to be revised to avoid that interpretation. Business personnel shouldn't be talking to people outside the company, suppliers or anything else about any risks, or things could get on a web. The internet seems to pick up everything these days. And finally, if a risky claim's unavoidable, you've got to work with marketing, try to modify it, try to make the claim maybe softer, not going to jump out quite as much, or at least raise some possible defenses for the claim. Even if you do all that, as we've just seen, you're still likely to, not likely, but you still may be attacked for false advertising. Now we'd like to go through a few of the things you can do if you are attacked for false advertising. Let's start with Jackie. I think you're going to start off with preemption.
Yep, that's right. So for preemption, there are two main categories of preemption, implied preemption and express preemption. Implied preemption can further be broken down into field preemption and conflict preemption. Field preemption occurs when Congress has so completely taken over a field of law that an inference of federal exclusivity is created. We do not typically see field preemption in the food and beverage class action context. Conflict preemption occurs when it would be impossible to comply with both a federal and state law, or a state law creates an obstacle to compliance with federal law, or maybe if it hinders the advancement of the policies behind federal law. As briefly discussed earlier, conflict preemption arguments have recently been raised in connection with the FDA's guidance on PHOs and challenges to organic labeling. In both areas, there have been recent court decisions denying preemption. So that's something to keep in mind and keep monitoring the briefing and the court decisions on conflict preemption and whether it's a viable argument in the context of the claims that are being asserted. The second category of preemption is express preemption. The NLEA contains an express preemption provision which prohibits the states from establishing any requirements that are not identical to FDA mandated or approved language or other matter. Accordingly, any claims that seek to apply labeling requirements that are different from or in addition to the FDA rules or regulations will be preempted. There is a difficulty in predicting preemption rulings. Preemption issues are rarely straightforward. Typically, the plaintiff is not claiming that FDA-approved language is used in an approved manner is deceptive. Instead, most claims involving preemption concerns are fact-intensive claims alleging an implied deception. In many instances, courts actually conduct an intricate legal analysis that can lead to different decisions by different courts. For example, the Ninth Circuit and the Third Circuit, in evaluating the same label claim on the same product, arrived at opposite conclusions as to whether a no trans fat claim on the front of a label is preempted. In arriving at their different conclusions, the courts interpreted the interactions of various FDA requirements differently and evaluated different guidance from the FDA, including warning letters and proposed notices of rulemaking. The differences in the court's approaches may also have been influenced by the specific allegations regarding the claims at issue in the case. So preemption is definitely a defense that should be evaluated and considered, but it's hard to tell where the courts will come out on different issues. So it's very important to monitor not just court decisions, but court decisions from different courts all across the country to determine what claims are preempted, what are not, and what the current status of the law is. So now I'll move on to primary jurisdiction. Under the primary jurisdiction doctrine, a court can stay or dismiss a case and refer the dispute to an administrative agency, here maybe the FDA, for a ruling. Reasons for the referral would be the fact that the judges do not have experience with the issue, a ruling would risk usurping the agency's interpretive authority, or a ruling would risk undermining the agency's considered judgments. Reasons against a referral would include the fact that maybe the courts decide the issue all the time, an FDA ruling may not resolve the issue, or the FDA may not rule, or the ruling may not be timely. As I had mentioned previously in the Swearingen v. Late July Snacks case, the plaintiff had alleged use of evaporated cane juice in the ingredient list, which is not the common or usual name of sugar, had violated state and federal labeling laws and was misleading to consumers. The defendant moved to dismiss under the primary jurisdiction doctrine in light of the FDA's notice that it would reopen the comment period on draft guidance related to the use of evaporated cane juice. The defendant argued dismissal was appropriate because the FDA's position on whether evaporated cane juice is a common or usual name for sugar has not been resolved. The issue is complex and requires technical expertise. The FDA is actively considering the issue, and dismissal would promote uniformity in labeling. The plaintiff responded that the FDA has a long-standing and consistent position that use of evaporated cane juice in food labels violates existing regulations, that final guidance would be non-binding on the court, that the claims being pursued are ones the FDA has no jurisdiction over, and that the forms of relief requested cannot be granted by the FDA. The court ultimately stayed the case under the primary jurisdiction doctrine, determining that the FDA as regulatory authority is actively considering the issue and is intending to issue guidance in final form. The court found the issue requires FDA expertise because it involves analysis of the method of manufacturing ECJ of evaporated cane juice and understanding the difference between evaporated cane juice and other sugars. Many cases, so ultimately they stayed the case on primary jurisdiction grounds. Many cases have declined to apply the primary jurisdiction doctrine to matters of food labeling, stating that allegations of deceptive labeling do not require the expertise of the FDA because that's an issue that everyday courts decide just in their normal routine decisions, namely just when conduct is misleading. Overall, a primary jurisdiction argument will not likely result in food claims being stayed or dismissed unless there's some indication from the FDA that new rulings or regulations are currently being considered or are imminent. Now I'll turn it back over to Aaron for a discussion of other pre-certification issues.
Thanks, Jackie. So early in a class action asserting false advertising claims, there's a couple other important issues to look at. Many state laws actually have restrictions on whether false advertising claims can be brought on a class-wide basis. And here, actually a decision from 2010 from the Supreme Court in fractured opinions is still resulting or continuing to cause uncertainty as to whether these state laws can form the basis of consumer class actions in federal court. Not to get too much into the details here, but the fifth vote in the Shady Grove case was really provided by Justice Stevens, who authored a concurring opinion, and courts are, for the most part, finding that his opinion controls. And under the framework that he set forth, whether a state law's restriction or prohibition on a class action will preclude litigation in federal court, also on a class basis, turns on whether the state law is substantive or procedural. There in Shady Grove, Justice Stevens determined that the New York law at issue was procedural. It was part of the procedural code of New York, and Justice Stevens held that it precluded litigation of certain class claims based on laws, whether or not those laws were New York substantive laws. So it would have precluded a class claim from asserted under, say, Pennsylvania law in New York court. The weight of authority is now that where a restriction on class actions is within the substantive statute itself, such as the Consumer Protection Law, that state law restriction is substantive and will not be trumped by Rule 23, so that the claim could not be brought in federal court on a class basis. However, there's a recent decision from the 11th Circuit that held a restriction on class actions that exists under Alabama's consumer protection laws. It's present in the consumer protection law itself and not the Alabama Rules of Civil Procedure. The court there held that the claims could proceed in federal court. The defendant has petitioned for rehearing en banc and before the panel, so that's one to watch in terms of what types of or what state laws can be asserted in federal court. Another couple issues to look at are related to standing. Many plaintiffs will attempt to assert claims against products that they did not actually purchase. So, for example, one flavor or variety of a product was purchased, and then the plaintiff will assert claims against the whole family of products. Where the statements on the products are different, so the product that the plaintiff purchased has a statement that's different than products the plaintiff did not purchase, courts have held that the plaintiff will not have standing. But where the statements are the same, some courts have held that the plaintiff will have standing to pursue those claims, at least on a class basis, against products that they did not actually purchase. Another issue is injunctive relief. Many of the state consumer protection laws allow plaintiffs to seek injunctive relief as well as monetary relief. However, there needs to be some basis for believing that injunctive relief is going to impact the particular plaintiff. So, for example, if the plaintiff is not going to purchase the product again, even if the labeling representation is changed, the plaintiff has nothing to gain from the injunctive relief. And this is important because the standards for certifying claims for injunctive relief are different than those for claims that seek monetary damages. And then other issues that can arise pre-certification are issues that relate to summary judgment. So depending on the timing of discovery, when certain discovery is obtained, and even sort of how long it takes the court to resolve a motion for class certification, there may be an opportunity for summary judgment briefing at the same time or before class certification briefing. So for example, if the named plaintiff was not actually deceived by the allegedly false claim, the plaintiff didn't read the statement or had a belief about the product based on something other than the labeling, summary judgment might be appropriate. Also, where the plaintiff hasn't provided sufficient evidence of whether the allegedly misleading statement is misleading to a substantial number of reasonable consumers, the claim should fail. This could come up either because the plaintiff did not have survey evidence or did not have direct consumer evidence. And then also where the plaintiff perhaps was not shown that the allegedly misleading statement is material to the purchase decision. So if the consumers would have purchased this product independent of what the misrepresentation is, then the claim is not material, and summary judgment would be appropriate. So turning next to class certification requirements, and we'll kind of move through these pretty quick. Class certification is governed by Rule 23 of the Federal Rules of Civil Procedure. Rule 23A sets out a number of standards that need to be met before a class can be certified. The claims must be numerous, such that you can't practically join all of them. There must be a common issue of law or fact for the class. The plaintiff's claim must be typical of those claims and relevant defenses for the class, and then the plaintiff and plaintiff's counsel must be adequate representatives. Because most of these claims are brought under Rule 23b3, which allows for certification where common issues predominate over individual ones, the question really turns out to be, what's the common issue and what are the individual issues? Courts are finding that among common issues is the issue of whether the allegedly deceptive statement is misleading to a reasonable consumer. This requires extrinsic evidence, which often comes in the form of consumer surveys. But against that are a lot of individual issues, whether you consider them in the context of ascertainability or in the context of whether you could manage a class action such the class resolution is superior to individual claims. You have to look at whether an individual actually purchased the product at issue. Putting aside what the purchaser thought, would this person have a claim? Then was that consumer misled? If the consumer was misled, what, if anything, on the package caused the consumer to have this belief about the product? And why did the consumer purchase the product? If the consumer purchased for reasons other than some belief about the product that's not true, that consumer is not likely to have a claim. And then also damages issues are often going to be individual unless plaintiffs and class counsel can come up with a theory that applies on a class-wide basis. Some claimants are attempting to avoid the impact of the individual issues by seeking bifurcation of individual issues and seeking certification for a first trial on common issues only. To date, we have not seen a court set up a framework to actually address all of the individual issues. Unlike, say, a breach of warranty case or product liability case, each of the individual purchaser's state of mind is relevant to liability. If the consumer was not misled, there's no liability to that consumer. And what we haven't seen yet is how courts are going to address that issue if they do certify a class. With that, I'll turn it back over to Jackie to talk a little bit more about ascertainability and some things we've seen there recently.
Hi again. Ascertainability has been recognized as an implicit requirement under Rule 23. Parts of that implicit requirement are that the class must be sufficiently definite that its class members are ascertainable, and that class membership must be defined by objective criteria. The Third Circuit has held that to satisfy ascertainability as it relates to proof of class membership, the plaintiff must demonstrate his purported method for ascertaining class members is reliable, administratively feasible, and permits a defendant to challenge the evidence used to prove class certification. The reasoning for this requirement was to eliminate administrative burdens, protect absent class members by facilitating the best notice practicable, protect class members by permitting them to identify themselves, and protect defendants' due process right to raise individual challenges. In Carrera, the court ultimately rejected both of plaintiffs' proposed methods of ascertaining class members and then vacated certification and remanded. The plaintiff had proposed identifying class members by retailer records and through affidavits, and the court found both of those to be insufficient. The district courts in California are currently split on whether to apply the Carrera approach to the requirement of ascertainability, some finding the Third Circuit approach to be acceptable and denying class certification on ascertainability grounds without an administratively feasible method for determining class membership, others finding it's enough that a class definition describes a set of common characteristics sufficient to self-identify, or others a middle approach. The issue is currently on appeal to the Ninth Circuit. The 11th Circuit has recently cited to Carrera and required an administratively feasible way to determine who's a class member. The Seventh Circuit has recently interpreted Carrera as opposing a heightened ascertainability requirement and has indicated that the underlying concerns should be addressed under the Rule 23B requirements. And then this is the image of some of the recent products that have been involved in the ascertainability cases. Now I'll turn it back over to Aaron, I believe, for a discussion of damages or individual issues.
Before we do that, this is Mike Flanagan. Let me interject. We obviously are going to go a few minutes past the 1 hour mark. We hope people can stay with us, but just in case, I did want to provide the CLE code. If you are in need of CLE credit today, please enter this code into the poll question on the screen after it and press the submit button. The code is G, the letter G as in great, D as in dog, the number 4, the letter E as in Edward, and the number 2. That's GD4E2. Again, if you're seeking CLE credit for this session, please complete the polling question by entering the code that was just announced. The polling question will remain open briefly. For those seeking Kansas, New York, and New Jersey CLE credit, in addition to the polling question, you'll need to complete the attorney affirmation form and return it to zrahim@foley.com immediately following the program. That form and the instructions can be found in the resource list widget. Thanks.
Thanks, Mike. So we talked a little bit about individual issues a minute ago. I think just to sort of keep us moving through everything a little bit better, I'll just turn this over to Craig to talk a little bit more about the damages specific issues. But just keep in mind that there are a lot of individual issues in false advertising class actions, and what we have yet to see is how a court is going to deal with all of these if they find that certification is actually appropriate.
Understanding the requirements that the plaintiff must meet in order to obtain certification, the requirements about damages, is very important. It's becoming a more frequent basis for the district courts to deny certification. Under the Supreme Court's decision in Comcast Corp versus Behrend, the court made clear that the plaintiff has to have at least what appears to be a method to measure the damages across the entire class, all the members. This is, of course, assuming that once liability is established and all the defenses fail. In a number of cases, the plaintiffs have not been able to come up with that type of method. And that might sound strange at first, but when we probe into the issue of, well, what is it exactly that the damage method has to do, it becomes a little clearer. The damages that are recoverable are generally recognized as the difference between the price that's paid and what the value of the product is. Another way of looking at it, it's how much more was paid because of misrepresentation was made. Every product almost has some value. A misrepresenting caffeine drink has value. It provides hydration, flavor, energy. The only cases in which you could get a full purchase price and have to prove that difference would be if the product totally had no value, for instance, medicine that didn't work or anything else. But in calculating what that premium is, the courts just don't look at the cost of the ingredients that went into the product. It just doesn't look at what the competitors are doing and saying and charging. It also looks at whether or not there's the brand name is available, how famous the brand name is, how much advertising was done. It looks at all the factors that could go into the product and brand loyalty. So understanding that and the burdens they have to go through and whether they meet it is often, it might be last ditch, but it's an important way to defeat certification. So now let's briefly go over what happens if you do get sued or threatened with a suit. first thing to do, of course, always check insurance coverage. Self-discovery. Get to the people who know where the skeletons might be once they know what the issues are, where the problem documents exist. You need to know, this is all part of trying to find out what's our risk here. How are we on the merits? What's our monetary exposure? We just talked about damages. Well, the monetary exposure should be calculated both in terms of the sales and in what you believe you could show would be any premium price that could be attributable to a false representation. A lot of companies want to consider the impact on trade customers. The trade customer could be sued, could be at least subpoenaed, or just might think less of selling a product that's been charged like that. All of these are things that start working into the evaluation of whether or not you should be seeking settlement. Obviously, you put all these pieces together along with an evaluation of likelihood of successful defense on the merits and opposing the class certification. Those are two different issues, really, and they have to be both viewed differently in the two stages. Just briefly look at expert needs. How much is the case going to cost? Early settlement. If you can't reach an early settlement, then you really should initiate an aggressive defense. The plaintiff's lawyers are here for a quick strike. They don't actually like to litigate a lot of times, and an aggressive defense quite often drives down what would be an unreasonable asking price. Speaking of settlement now, most are on individual, not a class basis. That means that even though you settle with the individual, somebody else can come along from the same state, different state, wherever, and bring the same claim against you. It can even be brought by the same plaintiff's lawyers. Under the canons of ethics, you cannot get the plaintiff's lawyers to agree not to bring more suits against you. You can get them to represent, though, in the settlement that they don't know about any other plaintiffs. Why do we want to? Quite often, the plaintiff's lawyers are sending letters before they file, maybe with a draft complaint. Why are they doing that? Because they look for a quick settlement without having to address the defenses that we've discussed here today that could be raised initially, like standing. Pre-filing settlement. Why should be considered? Copycat suits. We talked about how they multiply. If you can demonstrate that the sales are small and the likely damages, the premium price is small, drive down the plaintiff's counsel's expectations, and it's probably going to be less expensive than litigating through the certification decision, or even maybe the initial filing of motions to dismiss. Finally, though, if you got a large monetary award, we heard about awards of $3.5 million just to the lawyers and all these funds being set up. You may need to take your shot if you think there's a possibility of motions to dismiss, motion of summary judgment, or going through all of those class action requirements where you could attack it and prevent it from being certified. If you prevent certification, the case is over. Plaintiff's lawyers aren't going to pursue one plaintiff. That's why knowing and understanding the rules about certification are so important to a defense. And with that, I believe we're completed.
Okay. That brings us to the end of the formal presentation. A number of questions have come in during the course of the program. We'll attempt to get through at least a few of them. If we don't get to your question, I apologize in advance, and we'll attempt to follow up with you directly. With that in mind, the first question on the list, will the Supreme Court's decision in the competitor Lanham Act case, Palm Wonderful versus Coca-Cola, affect consumer class actions?
Okay, this is Craig. It shouldn't. That's the should. The court noted that the Lanham Act was a federal statute, not a state statute, that did not preclude, and that the Lanham Act didn't preclude actions for matters regulated by the FDA. The FDA, through the NLEA, however, has an express preemption provision respecting state claims, so it really shouldn't be impacted, but we've already seen one district court in ruling on preemption talked about how they were influenced and somehow suggesting that the reasoning on the preclusion, which is totally foreign to the issues of preemption, was affecting the decision. So that's one we're going to have to wait and see, but it shouldn't affect it, no.
The second question has a more practical bent to it. The question reads, some commentators have suggested looking at what the competition is claiming as part of the clearance process. Is this a good idea?
No, it's not. As we saw, if everybody's making the same claim, it sort of makes it a attractive target for the class action plaintiff because they can pick off one after another. Moreover, we're seeing cases filed constantly against claims that have been being made in the food and beverage industry for years, decades in some cases, where nobody ever claimed that it was deceptive. Competitors didn't claim it was deceptive. But if all the competitors are joining in, though, of course, that's a reason it's a better target. So I don't think that that's a good idea. Each excuse me, new advertising or label has to be evaluated on its own merits.
Okay. And Craig, I think this one is a follow-up on your discussion about damages. Is there any greater liability for a false claim that is in violation of FDA regulation versus one that's unrelated to the regulations?
Theoretically, no. But practically, it is a greater problem. First, if it violates the regulation, it's going to be per se deceptive. Second, such a finding would help plaintiffs argue that the deception was intentional or with willful disregard. And with that, we've talked about the actual damages, but they can try to justify an award of profits as opposed to the actual damages and unjust enrichment. And it just, if you have hopes of ever fighting the matter and defeating it at the different stages and not raising issues of fact, it's definitely a bad fact against you.
A question on deterrence. Is there any information that class actions are a false advertising deterrent?
Well, they've become a deterrent to making claims that are frequently attacked. But as far as the idea that it's a deterrent in the way of making people generally more cognizant of the risk of making a false claim, it really hasn't done much in that. Because companies are getting surprised because of the, I guess you'd call it, some of these claims are pretty far out, so you couldn't have been anticipated anyway. If you have a good clearance process, that avoids it. Now, in some cases, even when companies think there's a claim that's defensible, they're not making it because it's become a target, or it seems too closely related to something that is a frequent target. So but the idea that that's the justification which some courts are using when the basis for certification looks pretty weak, well, it's a deterrent. I don't think that's really correct. It's more of a handicap against aggressive marketing, but truthful by corporations.
Okay. Aaron, here's one that came in as a follow-up to some of your comments. The question is, do you expect to see an increase in cases over green labeling and sustainability claims on products based on the Chiquita Banana lawsuit and settlement?
Sure. I would say probably generally yes. I would expect to see more claims in the green labeling, sustainability, sort of the overall greenwashing category. The FTC has revised over the last few years its guides on green advertising. I think as we talked about a little bit before, some of the places that plaintiffs' lawyers are looking to are guidance from federal agencies, and the FTC has has been active here in warning letters and other cases related to greenwashing. So I would not be surprised to see more cases sort of in that green space, environmental benefit type claims.
Okay, with that, I think we need to wrap for today. Again, if there were one or two questions that we were not able to, actually more than that, that we appreciate the interest. We will follow up with you directly if we were not able to get to your question live. But this wraps up our program for today. Thank you very much for joining us. We invite you to contact any of today's speakers if you have additional questions or would like more information on their particular topics. Thanks, and have a